Continuing with Part 2, Motion Hearing, January 19, 2007. But it appears to be, at this point, more of a work in progress, for the reasons that I have said. Some of the items the state contends that it has turned over. The materiality of other types of evidence may still yet to be determined and may trigger at some point in the near future, an obligation to turn over additional information. Next, the court will take up the defendant's motion to exclude computer-generated animations. And when I say take up, I'm just going to address it and recognize it as being outstanding. The court has been provided earlier this morning with information that is in the subject of the defendant's motion. I will, because of the proximity of today's date and to the start of the trial, get an explanation from the defendant of the basis for the motion on the record, and also, hopefully, get some idea from the state of the reasons for which the information will be provided, as they may have relevance in determining whether or not the information is admissible. Who is going to present the state's position? Mr. Strang, the defense position. It's your motion. Attorney Strang, I will. I understand the court hasn't had a chance to look at the 3 animations at issue, and, indeed, neither have we. We received the same CDs or DVDs today. The court has not until now had copies of the slides, for want of a better word, for 2 of the 3 animations. The simple point, though, that ought not to get lost in the shuffle here is that I believe early on, in fact, probably before Mr. Muting and I entered our appearances, Mr. Avery invoked his discovery rights under Section 971.23 without reservation. And it's a little bit unclear to me here how the state would explain or justify, with good cause, the failure to disclose these exhibits, particularly the FBI animation, as to which we have seen nothing at all until today. I assume on the CD or DVD we have is gauged against the December 15th, 2006 discovery cutoff. The underlying information, I think, in these animations isn't something newly discovered, isn't something that the state got only from the defense, and does relate to the information and physical items that the state has had in its sole custody, at least as to the Toyota since November 5, 2005. And as to the Avery property, the underlying information, as I understand it, is drawn from the state's 7 or 8 day exclusive possession of the entire Avery property, again from about November 5 to November 12, 2005, where even family members and people who lived on the property were excluded by the state. So there is a tardiness issue here that is a separate from and stands independently of the question then of relevance, completeness, fairness, at a 904.03 bouncing that I have addressed at greater length on brief, as to which there's no point in my offering further argument until the court has had a chance to look at the exhibits. And for that matter, the state hasn't had much chance here to respond in writing, if that's its wish. The court, all right, who will be handling this for the state? Attorney Kratz, I will, Judge. The court, Mr. Kratz. Attorney Kratz, first and foremost, Your Honor, let me explain what we're talking about. There are 3 different areas of generation of summary exhibits that the state has had performed. Those include a computer-generated virtual tour, if you will, of the Avery property itself, which includes buildings and curtilage which basically surround the Stephen Avery trailer. We have also asked for and have received a representation or series of representations to assist one of our expert witnesses, the anthropologist in this case, in describing what human remains was recovered to better assist the jury to understand from where the human body, where on the skeleton, to be blunt about it, these items may be found. And lastly, we have performed, through assistance of the FBI, a representation of the victim's vehicle, which was recovered, which is, this court and defense knows, is of a highly probative nature, and items found within. Mr. Strang's submission, which I do request an opportunity to respond to in more detail, makes claims like the angles depicted in the computer-generated animations are not such that a human could make, and that's true. I guess that's the point of demonstrative evidence. Demonstrative evidence, rather than the original evidence, rather than the thing from which the demonstrative evidence is generated, is to assist the trier of fact. And the only thing that a court has to determine, at least from an admissibility standpoint, is whether or not it's a fair representation of what it purports to show. Now, the state today, so that the court understands what we're talking about, has provided 3 CDs, 3 discs, which are examples of those summary exhibits. I couldn't disagree with Mr. Strang more about the state's requirement or obligation to provide these things to the defense. The defense is entitled to the actual items that are seized or measurements of, or business records or phone records or photos, but they aren't entitled to summary exhibits. They are not entitled to maps or timelines or charts or diagrams. And even though these 3 animations are computer generated, they clearly within the category of a diagram. If we go into the most basic kind of diagram that juries sometimes see in an automobile accident, the diagram of an intersection, kind of an overview, where was the car coming from? Well, that's not an angle that is available to the human eye, but nobody would suggest that's because that's from a different angle. That's somehow not relevant or not of assistance to a jury. So to suggest that because I think Mr. Strang is arguing so nicely done because it is of a high-tech nature, because it's computer generated, somehow that goes to its admissibility. It is somehow prejudicial to Mr. Avery. We do disagree. We will be able, at trial or before, if the court wishes, a more detailed offer of proof to demonstrate how this demonstrative evidence, how these summary exhibits will be of benefit to the jury, so that the jury can see an overview presentation where specific evidence is found, how it may relate or interrelate to other evidence, and how, certainly, it is not going to be cumulative. These are very well done. The timing of them was for the state's presentation of its case in chief. I provided them to the court and to the defense as a matter of courtesy. That's how I'm looking at my provision of these. Again, I don't think the entitlement to summary exhibits occurs until the very moment the day witness intends to refer to them at trial. But in order to speed up the trial process, which we're all, I think, sensitive to in this case, I'm happy to have the court review these matters and to issue a pretrial ruling. And again, I would ask for an opportunity for more detailed argument if, in fact, after reviewing these, the court has a question as to their materiality or their relevance at the time that might come up. That's all I have at this time, at least for today, Judge. Thank you. The court, Mr. Strang. Attorney Strang, I agree with the counsel up to a point that if this is properly viewed as a summary exhibit under 910.06, which certainly the state is free to argue on brief, that it's the underlying physical items that the defendant is entitled to see or examine or to have as a matter of the principal discovery statute, section 971.23. I don't agree that the timing of the disclosures of this exhibit, therefore, is unimpeachable. The defendant certainly is entitled to have this jury not consider irrelevant, unfair, or overly suggestive or unhelpful demonstrative evidence to the jury. This court set a December 15 deadline for motions in limine, which would certainly ordinarily be the way to address demonstrative evidence or summary exhibits or other things that might be excludable as not relevant or under section 904.03. And to time that with a discovery deadline on the same day by disclosing this after December 15th, I'm in no position to make a motion in limine by December 15th, and my motion in limine to that extent necessarily is tardy, although I think without fault, because I can't move to exclude that which I haven't been told will be offered or shown. So the timeliness in the sense here very much remains at issue. And again, the other details about the fairness of the presentation are probably best addressed on paper and then by the court's review and ours of the exhibits themselves. The court, all right. Neither party is asking the court to make a ruling on this particular matter today, and since I haven't seen it, I think that's appropriate. The other comment I would reiterate is that this offered exhibit or set of exhibits, whether they are admissible or not, may not be determined simply intrinsically by the exhibit, but the purpose for which it's offered. At this point, I don't know that yet. The fact that they don't show shrubbery or foliage, I think that was mentioned in the defense's motion for some purposes that may be significant. For other purposes, it may not be. So in order for the court to evaluate the defendant's motion, I'm not only going to have to see the exhibit, but be informed as to the purposes for which it's offered. And it's my understanding, counsel, that we're going to take this up at the final pretrial on February 2nd. Attorney Kratz, that's fine, Judge. The court, okay, the next item, which I believe should be brief, is a court based on the stipulations submitted by the parties concerning the exclusion of a witness at the trial, drafted a proposed order. The court received a response from the defense with a couple of suggested modifications. I didn't receive anything back from the state, but I do take it at this point that with the modifications suggested by the defense, that form of the order is acceptable to both parties. Attorney Kratz, the court may recall that this was the subject of a written stipulation by the parties, and since Mr. Strang and I jointly drafted that, we don't have an objection. Mr. Strang included in at least the court's form of the exclusion order one suggestion. With that one variance to the court's offer, the state doesn't have any objection to that exclusion order be adopted, and the court can enter that order. Attorney Strang, just so we're not going to pass each other, I think I actually made two changes. I don't have it in front of me. The court, right. Just for my own information, Conrad Baez, is he a defense investigator? Attorney Strang, yes. The court, very well. The next series of motions that has been presented for the court's consideration deals with the evidentiary matters, which, for the most part, I believe the state wishes to argue and are inadmissible for, among other reasons, being not probative and unduly prejudicial. And the state has asked the court to hear argument on those motions in camera. So before getting to the motions, I will hear from the state on its request to consider these matters in camera. Attorney Fallon, yes, thank you, Judge. The state does request that these matters be addressed in camera. As the court and the parties are aware, there's been a flurry of briefing which occurred since the first of the year on third-party liability and blood vial evidence. I've asked in our pleadings for oral argument and that the argument be an in-camera argument. My reasons are these. First and foremost, there will be a great deal of discussion among the parties regarding the facts which may or not be facts heard by the jury. For instance, if the court determines the evidence to be inadmissible, then those facts which are not going to be disclosed are heard by the jury. And given the nearness in time to the jury selection process and potential for such prejudicial and possibly inflammatory argument, in fact, the statement being made this close in time to the selection process, one runs the risk of contaminating by the jury pool. Additionally, the three matters to be discussed are all interrelated. The state sees the interrelationship far stronger than the defense, but I think the defense would agree that to adequately discuss these motions, there will be a variety of facts that need to be brought out on record and discussed and argued, as a result of which we do not want to run the risk of potential contamination of the jury pool this close to the jury selection process. So that's why the issue of third-party liability and the admissibility of the blood vial evidence, and thus the subsequent bias issues, need to be addressed in camera until a ruling is obtained. And that is the basis for our request. The court, Mr. Strang, Attorney Strang, the court is correct that this is the state's request that the court take up facts and available possible evidence that will have a great bearing on this trial outside of public scrutiny and outside the hearing of the media. The state has offered some good reasons for that. I don't stand opposed to that today, in part because I'm relying on the council's assessment of where the factual discussion could take us. In the end, of course, this is one of those issues on which the court cannot defer to the parties, because the court has to speak for the broader public and speak for the First Amendment. And I don't presume to undertake that role or tell the court how it should exercise its overriding public duty in that respect. I do say that I don't understand the state, by the use of the term in camera, to be seeking to exclude the defendant himself, and would ask that he participate. I understand it to be the public and the public's representations of the media that would be excluded, and I tender the decision to the court. The court, all right. First of all, that is also the court's understanding of the state's request. I don't believe the state is asking for the defendant to be excluded. I will state for the record, when I received the written arguments of the state and read the request, I took the opportunity to explore this issue a bit. Under Section 757.14 of the statutes, they provide that sittings of every court shall be public. And that is certainly the general rule. It is extremely rare that the session court can be closed. I've been on the bench for almost 10 years, and I don't believe I've ever closed a session of court. However, the law is that in certain rare situations of a sitting of court can be closed. The leading case on the issue, as far as I can tell, is State ex rel. Lacrosse Tribune versus Circuit Court. It's a 1983 reported court decision. Some of the most important language in that decision for our purposes reads as follows. It has long been recognized that the requirement for public trials is subject to certain inherent powers of the court to limit the public nature of trials in certain respects where the administration of justice requires it. The circumstances necessary to trigger the discretion to close the courtroom must be compelling. One circumstance which arguably could trigger the trial judge's discretion to close the court is that a fair trial could not otherwise be had. The trial judge should recite on the record the factors that impel him to close the courtroom and why such factors overrode the presumptive value of a public trial. Finding a fact must be made with specificity, process must be a rational one, and the rationality of it must be demonstrated on the record, showing that the conclusion was reached on facts of record or which are reasonably derived by inference from the record. A trial court is required to hold a hearing and publicly reach a conclusion based on the exercise of discretion prior to ordering a closing. The parties and members of the public present in courtroom may appear at such hearing, that is, the hearing that we have today, which is on the record. As I've said before, closing of court proceedings is rarely done, but I do find that in this particular circumstance, there are circumstances which justify that decision. I will be repeating some of the arguments made by the parties, or primarily by the state here. But I first want to note for the record, the court is aware that this case has received, at least for purposes of this county, unprecedented public coverage. This has included live television coverage of most of the court proceedings, and in addition, video of the court proceedings in their entirety have been posted on media websites for purposes who are not otherwise available to view the proceedings. As a general rule, the court views this as a positive situation, that is, it enables the public to see the court system in action. Court proceedings are supposed to be public, and the participation of the media significantly assists in that regard. However, it can pose problem in a case such as this where publicity concerning the pretrial hearings is widespread. and we're dealing with the disputed matters relating to important pieces of evidence to the parties that some of which may be determined to become inadmissible and could be highly prejudicial and threaten fairness of the trial. In this particular case, we're within 10 days of the beginning of the jury selection process. This trial has already been delayed once for a number of months, and one of the important reasons advanced for the delays was the existence of previous publicity that could well be considered prejudicial and threaten the fairness of the trial. Given the fact that the trial is not going to be starting until approximately 15 months after the alleged offense, it's important, I think, to not unduly create a reason for another adjournment. The court also notes that it's impossible in this case to particularly to successfully insulate potential jurors from the publicity that comes out of today's hearing. The jury is going to be selected from Manitowoc County. This is not a case where we're bringing jurors in from a far-flung part of the state where they might not be exposed to the publicity from this hearing. As I indicated, it's not just a normal motion hearing. It's a motion hearing that deals with evidence which is alleged by one party, in this case the state, to be inadmissible and to be arguably inflammatory and highly, potentially prejudicial to threaten the fairness of the trial. Finally, I will note that I believe that the disadvantages of holding the hearing in camera can be somewhat alleviated by the fact that, to the extent the court issues a decision, and I will indicate in open session it's not likely to be issued today, I'm going to want an opportunity to review the arguments of the parties and their written submissions, many of which have been received simply in the last few days. But at such time as the court issues a decision determining that any evidence is admissible, that ruling will be made public and immediately available to the public and to the media. So for those reasons, the court finds that the consideration of the evidentiary motions that remained that have been described by the state on the record will be necessarily be conducted in camera, that is, out of the view of the public. I will take a recess at this time in order to permit the courtroom to be cleared, and then we'll resume with the hearings. Mr. Gahn. Attorney Gahn. Judge, I have just one very quick matter. I believe Mr. Kratz also does. Regarding our issue number 2 this morning, the demand for compliance with discovery, we had asked on page 8 of our brief that the compliance be completed within 3 days. I would ask the court, would you make that part of your ruling? The court. First, I would want to hear from the defense as to the feasibility of that. Attorney Buting, give me just 1 second to look back at my notes here for what I have to do. And 3, we're talking about 3 business days where I'm going to have to contact the court. Let's name a day next week. I assume you're talking about. Attorney Gahn, yes, you'll not include the weekend. The court, Wednesday. Attorney Gahn, that will be fine, Your Honor. Attorney Buting, I think that should do. Yes, that would be the court. 31st. Attorney Buting, no, 24th. The court, I'm sorry, I'm a week ahead. Wednesday, the 24th. Attorney Gahn, thank you. The court, Mr. Kratz. Attorney Kratz, 2 things, Judge. The court set today as a date by which the state should file proposed jury instructions, and recognizing that these may change and evidentiary rulings may affect them. I have that document for the court, and I want the record to reflect its filing. Secondly, the court has asked that if either party contemplated the inclusion of any images, that is, photographs or other images within its opening statements, PowerPoint presentation, or however else that may be included in its opening, that those be provided to the court by today's date. I have prepared a CD with the images the state intends to include in its opening. Both of these submissions, I should tell the court, have been provided to Mr. Strang before the start of this hearing. Attorney Strang, I acknowledge receipt of both. just as Mr. Kratz says. And I will note as well that he provided 2 letters to facsimile to the court and the council, both dated January 18, 2007, although I think only facts ordered this morning to the court and council related to the proposed jury instruction. The court, all right, I understand. I believe when I read Mr. Strang's letter, he indicated that because of the court's motions that have not yet been resolved, it was impossible to submit necessarily all jury instructions requested by the defense. I understand Mr. Kratz to be saying the same thing for the state, and the court understands that both parties will be given a chance to supplement their request for jury instructions pending the outcome of outstanding motions. Attorney Kratz, do we know whether the defense intends to offer any images during their opening statement, or whether they haven't, or they even intend to give their opening at the start of the case? Attorney Strang, Attorney Kratz, if so, I ask for some notice or opportunity to object, just like the state has given. The court, I don't believe they are required to state today whether they are going to make an opening statement. Attorney Strang, I'm not, but I will, and I will be giving an opening statement, or we will, probably I will, I expect immediately after the state's. And my present intention is not to use exhibits in that opening. If that changes, I will disclose that to the state and to the court if it wants, just as soon as I change my mind about that. But that would be a change of mind. Attorney Kratz, that would be just fine, Judge. I don't need more notice than that. That's fine. The court, anything else before we take our break? Attorney Fallon, no. Attorney Kratz, no. The court, if not, let's report back in 15 minutes. Recess taken. The court, at this time, we're back on the record. As I announced previously, this portion of the proceedings is conducted in camera, and the public is not present in the courtroom at this time. The next motion that I had up for this consideration was the Denny Motion. Specifically, the defense filed a statement on third-party responsibility indicating that at first point that Denny did not apply in this case, but in the alternative, if the court determined that Denny did apply, the defense identified a number of persons who could be considered possible perpetrators of the crime and explained the offer that would be made of evidence to support these allegations. The state filed a memorandum to preclude third-party liability evidence. Will Mr. Strang or Mr. Buting be handling? Mr. Strang, you may proceed. Attorney Strang, thank you. Let me just take care of a housekeeping issue first. We have a Manitowoc County deputy in the courtroom who is a court officer. And I think for as much as for his own good as anything, since his possible testimony or facts about which he knows may come up at some point along the line here, we may want to excuse him that he is clean, so to speak, and not subject to a cross about what he may have overheard hearing on the subject matter of his possible testimony. I don't have any problems with this guy in particular. Just probably is a good thing to do. Deputy Riddle. The court. Well, we have Attorney Strang. Oh, and we have Deputy Tax too. Okay. The court. Does the state wish to be heard? Attorney Fallon. This seems to be a security-based issue. We'll defer to the court and counsel as to how you wish to proceed on this. To me, I don't see it much of an issue at all, but if Mr. Strang has some significant concerns and the court has agreed, that's fine. I think the determination should be made from security-based, and if there's another officer available, great. If not, then court will have to make a determination whether you want to proceed with just one bailiff. The court. Let me suggest this. We're in here on an in-camera basis. What if the Manitowoc County bailiffs step just outside the door instead of just inside? And that way we'll have some level of security. But to the extent of some of the motions involving testimony about Manitowoc County Sheriff's Department employees have not yet been addressed yet, I assume that can take care of the defendant's concern. Attorney String, absolutely. I'm looking to avoid an issue rather than create one. Stepping outside the door will be fine. Mr. Avery has been fitted with a stun belt. I don't know who has the control of that, but the court. We have 2 Calumet County officers here. Attorney String, then we're fine. Then we're just fine. The court. Very well. We'll just wait just a couple of minutes if you want to stand outside this door, Gary. Officer Tax. Okay. Michael will be out one door and you will be out the other. Attorney String. You know, Your Honor, I wrote a fair amount on Denny, and I really have no desire to blather on for the sake of hearing myself talk. So if there's some focus of the court can give me or a particular issue to address. The court. Actually, I'm just giving you an opportunity to supplement your memo. I will indicate that I have read the written submittals by the parties on these remaining issues at least 4 or 5 times already. But at the time you wrote yours, perhaps you did not have the benefit of having receiving the state's response. So if there's anything else you wish to present at this time, I will receive it. Attorney String. Okay, well, I do think it's important here at least to try to separate Denny, which, you know, is maybe significantly different on its facts than this case to begin with, from Richardson. If only because the Wisconsin Supreme Court in Richardson said this isn't Denny, we're not going to apply Denny in this context. Indeed, we're going to reject the state's invitation to apply Denny in the frame-up context that Richardson addressed. And Denny is not even a good fit, so to begin with, as I argued on brief, and I shan't repeat that. But the nitty-gritty here is when we suggest that there are others at the Avery property who had the same or no less apparent motive than Stephen Avery to commit the crimes alleged in the amended information, and who had the same opportunity and about the same direct connection, that really is about as far as the facts will allow the defendant to go here, where the defendant's own assertion that I'm not guilty always factually has been at bottom, an assertion that I just didn't do it, and I can't shed any light for you on who did. And there's no real persuasive motive that the state can offer for the crime. That is, you know, this isn't a case where the victim owed the defendant money, or there was a divorce ongoing, or, you know, any kind of usual sort of causes of human action, the usual reasons that might lead to a homicidal anger or to passion getting out of control, you know, murderous passion, not amorous passion. We're really in no better position to tender a motive on the facts here than is the state. And that really is very different than Denny, where very evidence that the defendant wanted to offer was evidence of someone else's motive. He had, you know, a motive that he wanted the jury to consider that another person had. So it's a tough fit. The court. Let me ask this. Attorney String. Sure. The court. Denny doesn't require a defendant to come up with Denny evidence. The defendant certainly here is not obliged to say that other persons could have done it, so I didn't do it. The burden is on the state to prove that the defendant, did do it. Attorney String. Right. The court. But I didn't understand your pleading to be saying that you didn't want to offer evidence others did it. That is, not just the defense, as I understand it, is not simply going to be that the evidence is not sufficient to prove that Mr. Avery committed these crimes, but rather to identify, if not one person, a group of other people who did. And it seems that type of thing does get into your Denny, does it not? Attorney String. It can, and then certainly, as I see the argument and the trial unfolding, factually, you know, we'll be saying what the investigative scrutiny did to some of these other people get. Stephen Avery became very quickly the focus of the investigation, and the state will say, well, that's right, and we've got good reasons for him being the focus. What we want the jury to understand is that the truth that there were others who, at least initially, looked about equally situated as potential suspects. and not much investigative effort was expended on exploring whether they were good suspects or whether they were easily excluded and therefore not viable or good suspects. And at that level, if I understand the court, I think that's not Denny at all. That's something we're free to do. And this is where I do agree with the court that much of what we have presented in writing orally overlaps connects up at some very general level, in that you're getting to a bias issues, an investigative bias, or a tunnel vision on one person of particular interest, when in fact an objective investigation might have looked at other people more seriously than the state did. The court, let me stop you right there. Who is going to handle this for the state? Mr. Fallon? If one of these state's investigators is on the stand and they give their testimony, and the defense says, well, why didn't you investigate further other people you determined who to be on the scene on the date of the alleged crime? Does the state take the position that they've got to make a Denny showing to ask the question, or can they ask it from the state's perspective? Attorney Fallon, Your Honor, I think that's just a backdoor way of introducing the potential of a third-party liability suspect. And I guess I'm sitting here listening to the court and counsel to begin the argument. The first thought that comes to my mind is simply this: does the defense want to introduce the evidence set forth in their statement of third-party responsibility, either in their case in chief or on cross-examination? Do they want to do that? The court, I wondered the same things, but we haven't gotten to that yet. Attorney Fallon, because I'm treating it as a motion for introduction of that evidence, and do they want to argue that one of those individuals could have or did commit this crime? Then I can respond to that. I think we're miscasting the issue. The court, I'm trying to take this in the order in which it may come in. I'm saying that, and I asked myself this as I was reading the briefs, if the state or if the defense on cross-examination asked an investigating officer or officers why they focused in on one defendant and did not investigate other suspects further, or maybe they did investigate other suspects at this point, I have no way of knowing without referring to a specific other suspect. My own feeling is that at least that question doesn't get you into Denny. Attorney Fallon, it depends on what they want to do with the answer. And then the question is, well, why is it relevant? Counsel will say, well, it goes to bias. Since when is bias an institutional conundrum? The court, it may go to bias. Attorney Fallon, then why is it relevant? Why is it material to whether or not Mr. Avery committed the offense? Sure, they can ask the question. My concern is, what are they going to do with the answer? What are their arguments to be made? It's a backdoor attempt at pointing a finger that somebody else committed the offense. Otherwise, the jury is going to get sidetracked. That's the whole point behind Denny. That's my take. I will let the court and counsel continue. The court, all right. Attorney Strain, let's go at this from an element standpoint on the homicide charge. The jury has got to find that someone has been killed. And let's suppose the jury finds that they are satisfied that Teresa Halbach is killed. Then the next two things we have to decide are, was it Stephen Avery who killed her, and did he do it intentionally? Those are the elements. And, we can't hop over that second element, which is it the defendant who killed her? One of the reasons that a jury reasonably might doubt whether the state has proven that he killed Teresa Halbach is to say to themselves, gee, I haven't heard any reason he would have to kill her that's any more compelling than the reason that his brother might have had to kill her, or that Scott Taddock or Robert Fabian might have had to kill her. And I understand that they were there, and I don't think the police looked very hard at, for example, the fact that Earl Avery and Robert Fabian are very different times for when they are out on the rabbit hunt, which is a short hunt. Strange to do it at darkness. And gosh, both of them have .22 rifles in their hands. although the police didn't bother to ask that either. And we understand that Mr. Avery's back door to his trailer was broken open, and we don't know why a family member of his or who's riding around on a golf court on the property couldn't have gone into the back door of his trailer, either to put the .22 rifle there or to take it from there, or both. And we're interested in the fact that a cadaver dog hit on the golf cart that Earl Avery and Robert Fabian said they were riding around on, which gets concealed in Ms. Avery's, Dolores Avery's garage. We've got some doubts here about whether the state got the right man. I don't see that as being a Denny argument, although clearly it relates to other people in the same way that evidence would have to relate to other people. If, we were trying to, the 1912 attempt to assassinate Theodore Roosevelt outside the Gilpatrick Hotel in Milwaukee, where there was a whole crowd of people, and the issue might have been who's the gunman and the court. Well, let me ask you this. I'm reading from Denny and Al, and they conclude, while our decision establishes a bright line standard requiring 3 factors to be present, that is, motive, opportunity, and a direct connection, our holdings is consistent with the Lasecki language, Lasecki, regarding the term tendency. So how can you argue that to be entitled to show Denny evidence, you have got to have these 3 factors, but somehow you only have 2, don't you? You don't? Attorney Strang. No, I guess what I'm arguing is that I've got just as much as the state does on all 3. I can't tender a motive for one of these other people to have done this, but the state can't tender a motive for Stephen Avery to have done it. So it seems to me a surprisingly odd that the defense, which bears no burden, is in the position here of having to jump hurdles that the state is seeking to prove Mr. Avery guilty. Doesn't have to jump. And indeed, on request, will get a jury instruction saying that they don't have to prove motive, but I do, if I want to challenge his guilt by pointing out the court. How's that different from Denny? I assume that the jury instruction was there at the time of Denny and they showed motive. Attorney String. Because in Denny, it's a motive that the defendant wanted to offer. And the facts of Denny are that he was excluded from offering the motive of a particular third person. Evidence of that motive. Denny's tough. I mean, it really is. And, everybody talks about it, myself included, for years, as if it's an immovable and unchallengeable feature of Wisconsin law. It never went above the Wisconsin Court of Appeals. And the footnote in Richardson, where the holding is, we're not applying Denny here to frame up, the footnote is, we have never approved Denny at all. So I take it Denny is a published decision, it stands, but the court, there's a Supreme Court decision authored by Justice Crooks that applies to Denny. I forgot. Attorney String. Yes, the court. The name of the case, but Attorney String. Scheidel. Scheidell. There is. And again, I accept Denny as the law. It's not a great fit here, and how far beyond its facts it can't be applied isn't clear to me, and that's what I tried to address in writing. The proffer, and, Mr. Fallon asked a fair question. Do you want to offer this? Yes, we want to be able to offer the facts that we proffered alternatively if the court finds that Denny applies. And we want to be able to offer them if it finds that Denny doesn't apply. These are fair areas to explore, both as a matter of simple reasonable doubt and as a matter of bias that each individual investigative officer may have brought to the task here, where the person at issue was Stephen Avery. I guess, specifically, as I read Denny, the defense that I want to offer this evidence of a third person's motive. And I think that actual holding of, as opposed to the discussion and the dictum in Denny, is that if you want to offer evidence of motive of a particular third person, motive alone is not enough. You also have to offer some evidence, a plausible showing of whatever the phrase is, of opportunity of that third person and of some direct connection to the offense. So it's not enough to say, hey, I want to show that the decedent had a bookie who was mad at him because, he hadn't made good on his bets and had a reason to kill him. And when the facts are that the bookie and identifiable was in the city of New York when the homicide occurred in Milwaukee, Wisconsin, and had no opportunity to have committed it, then I understand Denny on those terms on why motive wouldn't be relevant, wouldn't be enough. This is very different. We're not seeking to offer a motive. What we're saying is that we have got the same evidence of motive, opportunity, and direct connection to the crime as to this group of people as the state does to Stephen Avery. The court, well, I agree with your summary of the holding in Denny. It is different to the extent that the defendant in that case, wanted to show evidence of motive. You're saying that's not part of what the defense argument. Attorney Strain, not here. I don't have it any more than the state does. The court, Mr. Fallon, Attorney Fallon, he has concluded his remarks. The court, I suspect. Attorney Strain, it's helpful to the court. Neither of you has had probably concluded your remarks. Attorney Fallon, that's what I meant to say. The court, but you're next, so you go ahead. Attorney Fallon, first of all, I take some issue with the three assumptions or statements of counsel. One, that they are already in the same position as we are with respect to motive, opportunity, and direct connection to the crime. One, I dispute that. But with respect to motive, however, the court has ruled our evidence of motive inadmissible. So, on the theory of law of this case, apparently we do not have an explainable reason why the crime occurred. However, opportunity clearly exists on this particular case, and more importantly, and most importantly, there is a direct connection because the defendant's blood is the blood that is found in the SUV. It's the bullet fragment containing the victim's DNA found in the garage. The key is to the Toyota is found in his residence. So there are direct connections unlike any of the others. Secondly, I take issue with counsel's characterization of Denny. Denny is not simply just about a defendant wishing to introduce motive evidence, although I acknowledge that's how the case got to the Supreme Court. The defense was denied the opportunity to introduce the motive of this third person, in particular the motives attributed to one Gary Peterson over a $130 debt, or the fact that Bill Cudahy also had a motive because a shotgun was exchanged for drugs, and that shotgun was ultimately sold, apparently, to the annoyance of one of the parties, as a result of which this Christopher Moore was killed. That's what our facts there are. But if the court's attention can be directed to the Denny decision, it's more than about motive. Motive was the means. That's the, as it were, if the court is a card player, that's the ante that gets you into the game. That's the jacks are better, to borrow a metaphor. But the point of Denny is that, and it's found on page 17. I'm looking at the Westlaw, the head notes 9 and 10, second paragraph. It says in words, there must be a legitimate tendency that the third person could have committed the crime. That's the whole idea behind it. Is there a legitimate tendency in which the legitimate tendency is the direct connection? The legitimate tendency is demonstrated by motive. It's demonstrated by opportunity and the whole connection to the crime. That's what we're talking about here. Those are the circumstances. That's the context of Denny. Now we're looking at the defendant's statement on third-party liability. What do we have? Again, our complaint is that 1, Denny clearly applies here. If they wish to introduce these facts in direct examination or in their case in chief, and then argue the inference to the jury that the police job was so bad, and by the way, look at how bad it was, these guys could have done it, then they have to comply with Denny. That's just cut and right. I'm astonished that counsel would say, that they don't have to apply, and that's not controlling here. The law requires that the court look at each person individually. So as the court goes through this, there are alternative Denny proffer beginning at page 9. They list 2 different categories, customer or friends category, and I think family category. So I'm going to address my comments specifically because I think the law requires that the court address them specifically. As to Scott Taddick, it's clear, and counsel acknowledges, that there is no motive presented there. Opportunity, sure, he is on the property, I will concede that, but there's no connection. As a result of the no motive, and most importantly, no connection to the crime, and that's key, it's not just the location, it's not the property, there has to be a connection to the crime. And that is the key here in analyzing all of these. There is no direct connection for Scott Taddick to the crime. Therefore, evidence cross-examined, case in chief, otherwise should and must be excluded. Next, you have Robert Fabian and Earl Avery hunting rabbits. Counsel points out, have a time discrepancy. Well, that's hardly unusual if there was a situation or a case. In fact, I doubt whether the counsel ever had one, because I'm not sure I have, where witnesses say the exact same thing at the same time and everything lines up perfectly. Quite frankly, when that happens, then I know something stinks. I have yet to see in my years of experience where everything lines up so perfectly. There's no connection, no motive, no connection to the crime, and just because he is on the property for that 1 hour or 2 hour period hunting rabbits, I suppose one could say that he had opportunity. So for purposes of the argument, we could concede that, but there again, there's no direct connection and no motive. Similarly, with respect to Andres Martinez, this one is rather interesting because I think Andres Martinez, again, there's no motive, there's no opportunity, and there's no connection. And again, if they wish to offer evidence of third-party liability here, I think Martinez is the potential admissibility of Martinez is governed by Scheidel to a certain extent because it's another act. Although here we apparently know that who the other actor is opposed to. And I think in Scheidel there was a question as to, I think it was an unknown third parties and the adoption of this Sullivan analysis. Well, whether you use Sullivan analysis or whether you use a Denny analysis, under either way, Martinez does not meet the requisite admissibility standards. Under Denny, there is no motive, there's no opportunity, and there's nothing to directly connect. If you want to take a Sullivan analysis, then one is the evidence offered for proper purpose, sure, to suggest that somebody else may have committed the crime. Okay, fine, that's the proper purpose. However, on the next 2 steps of the analysis of the Andres Martinez evidence is inadmissible. It does not meet the evidence, the relevance determination because, as the court is aware, relevance is a 2-part determination. If I may have a moment to elicit further, here it is. Relevance has two facets. The first consideration is whether the other act's evidence relates to the fact or proposition that is of consequence, and I think that's probably true in this case. However, the second consideration is whether the other act's evidence has a tendency to make a consequential fact more or less probable. And given the nature of the assault and when that assault occurred, it's one. It's so sufficiently dissimilar and unrelated to the circumstances of the Halbert murder that it fails on the relevancy prong. Then finally, even if it didn't fail there, it would certainly fail on balancing the probative value of Andres Martinez's assault of his girlfriend with its potential prejudicial effect. In this case, confusion is the primary concern here, delay, waste of time, and the jury going down the wrong road, as opposed to trying to determine whether or not Mr. Avery is in fact the murderer. So the fact that Andres Martinez attacked his girlfriend with a hatchet does not add anything of consequence to our analysis here. I don't need to comment further on these many inconsistencies to law enforcement. The court, before we leave before we leave him, I don't know if I missed it in the defense offer. What would be the evidence connecting Mr. Martinez to the location of the crime at the time of the crime? Attorney String, that's fuzzy. He, I think, on the end denies having been there on October 31st. And there's a receipt for his son's car having been towed there on November 2 days later. And he, in the end, says, well, that's the day I most recently went to the Averys. So it's others suggest that he may have been there and indeed been at the bonfire on October 31st. But, I don't have any ironclad evidence to put him there. Neither do I need to offer that. One of the things that's so striking about Mr. Martinez is that his first talk with law enforcement officers before he does start changing his story considerably on some interesting details about his relationship with Stephen Avery. His first statement includes that what most experienced detectives would have recognized as a confession to killing her, and sort of explored this strange statement, well, I'm going away for the rest of my life anyway, so I guess if they say I did it, I could take responsibility for it. That's exactly the kind of statement that people sometimes initially make in ultimately confessing a shameful crime. Rather than the sort of following that or going into the crack that Mr. Martinez offered, what we have these agents, according to the reports, saying is, we're not going to blame you for something you didn't do, and that's just the end of the matter. Really, an interesting bit of tunnel vision there. Attorney Fallon, I guess I would dispute that because I'm under the impression discovery has been provided, and there's also, I think counsel acknowledges it, they may not find it the greatest in the world, but there is an alibi associated with Mr. Martinez in terms of his location. I believe there's evidence that he was out trick-or-treating with his kids. Attorney Strang, with a 16-year-old boy who claims that he skipped school, that's true. But, we do have to avoid here, what we do have to avoid here is getting into the very problem that Holmes versus South Carolina warns about. Now, Holmes approves in his general rules like Denny, and in fact cites Denny as the sort of rule that's in general permissible, but says, look, you can't look in isolation at the state showing and say, boy, that looks like strong standing alone, so therefore I'm not going to allow competing defense evidence that standing alone doesn't look as strong. That's what Holmes is about, and particularly in arguing direct connection. That's really what the mistake the state is inviting the court to make here. The court, I understand what Holmes says, but as long as you focus on the evidence or lack of evidence supporting third-party involvement, I think you steer clear of Holmes' problems. If you say, I'm not going to look at your third-party evidence because there was DNA evidence connecting Mr. Avery to the crime, and that's enough for me, then you're going into a Holmes problem. Attorney Strang, right, I agree. The court, but I don't understand the state to be making that kind of argument here. Attorney String, well, they're saying, look, the keys found in his trailer and a bullet with Teresa Halbach's DNA or fragment of a bullet is found 4 months later in his garage. Now, in fact, there will be plenty of evidence at trial that Stephen Avery did not have exclusive access to the garage. Others went into the garage, and an issue why this bullet is found 4 months later after multiple searches of the garage. I mean, the jury will have all kinds of evidence to consider in assessing the weight, if any, to give that bullet, including the fact that the bullet has also got DNA from a state crime lab analyst on it. I mean, that's just where we have to be careful, because taken in isolation, finding a Toyota key in Mr. Avery's bedroom sounds terrible when you look at how many searches. The court, okay, wait a minute. I interrupted Mr. Fallon just to ask about the evidence of Mr. Martinez, so Mr. Fallon, you may continue. Attorney Fallon, thank you. After Mr. Martinez, the defense then suggests that a couple of adolescent schoolgirls, KS and a MCK, that there was a group of people at a bonfire. Again, those people apparently Mr. Martinez has mentioned a Don Hauschultz, German spelling, Hauschultz, Stephen, and Attorney String. This is all part of the Martinez discussions? Attorney Fallon, right. The court, yes. Attorney Fallon, so again, all right, then I'll accept that. Apparently, those aren't being offered as viable suspects. Next, you have James Kennedy, again, opportunity solely because he happened to be on the property at the time. The court, just before we leave that, when was this bonfire? I don't know if I caught that from the offer. Attorney Fallon, I believe that was supposedly the night before. The court, October 30th? Attorney Fallon, yes. Attorney String, no. Attorney Buting, no. Attorney Fallon, well, there certainly was a fire, and we're going to introduce evidence of a fire on the night of the 31st, but there's evidence of a bonfire before. The court, I'm looking at page 13, and it says a schoolgirl and her friend that Martinez, Don Hauschultz, Stephen Avery, and another Stephen had been at a bonfire and a party at the Avery residence. A MCK confirmed that she heard from Don Haynes that Martinez and his girl and his friends, Roberto Brooks, were at the Avery property on October 30th. When I put those two together, I read it as being a bonfire on October 30th. Attorney String, there are two different statements there, and one girl does place it as Sunday night, October 30th. The other doesn't. Attorney Fallon, I think it makes it all the more speculative and full of conjecture when one goes to analyze the admissibility or the possibility of any of those people, particularly Mr. Martinez, being involved. Attorney String, that's a tough argument for the state to make where its own witnesses are going to be in conflict over whether there was any fire on October 31st. It's certainly the state's theory that there was, but it's going to present people who say, I didn't see a fire on October 31. So none of this is ideally crisp and clear. The court, all right, Mr. Fallon, you may continue. Attorney Fallon, thank you. Again, with respect to Mr. James Kennedy, their Denny analysis, no motive, and no direct connection to the crime are offered, so evidence regarding him should be excluded. With respect to the panel members, you have Charles Avery is the first one mentioned. Defense argues, well, apparently he may have a motive, but his motive is no greater than their client's because of his sex offender charges and or convictions associated with both Charles and Earl Avery. As I noted in my pleading, one of them was actually convicted, the other was not. But there's nothing to directly connect Charles Avery or Earl Avery, for that matter, with the crime. Yes, they are connected to the crime scene when one considers a salvage yard as a crime scene or location, but there's not a direct connection to the crime itself. And such allegations need more before the jury is going to have a finger pointed at one of the defendant's brothers. That gets us to the Dassey boys, which there are four: Bobby, Blaine, Brian, and Brendan. We're accepting Brendan from this discussion for obvious reasons. That leaves us the remaining three Dassey brothers. Again, motive, the opportunity, and the connection are very, very thin. Motive, absolutely none. Connection to the offense, none. Opportunity, depending on which version of the time frame, arguably that could be conceded, but again, certainly insufficient evidence connecting them to the offense in question. As a result, under a Denny analysis for the defense to suggest and point a finger that one of the individuals mentioned in their statement is a viable suspect, such that a jury ought to consider that in evaluating the quality of the investigation is a reach. It's going to lead to confusion. It's going to have the jury going down who knows what path, and it doesn't add anything to the possibility or reality of what the jury's actual determination or job is in this case, and that is to determine whether Mr. Avery is, in fact, the one who killed her. If they're going to simply suggest and imply or directly say in argument that any one of these 6, 8, 10 people listed in that statement could have been the murderer, then they have got to have more than what they have shown us. So that evidence should be denied, Judge. Thank you. The court. Anything else on the Denny motion? Attorney Strain. I would be reiterating the brief, and I think, I will stand on that. I don't think I'm waiving a thing, but just to go back on the real basics here, I think Denny does not apply at all. If the court disagrees and finds that Denny does apply, then the facts we have offered in the alternative we do wish to pursue on the cross-examination conceivably in the defense case in chief. As I understand what the 904.03 limitations might be on cumulative questioning or other cumulative evidence, but the court does need to understand that some of the people we discuss, and James Kennedy, for example, would be a good example here. Don Huschultz would be another. Not because we view them as suspects themselves, but because they are in a position to offer testimony that bears on the activities of others. James Kennedy is there to say what he sees about Charles Avery and how peculiar it is that Charles Avery on October 31st, 2005 isn't in or around the office, and he has to be hailed by shouting for 5 minutes or more and comes from behind the building. And James Kennedy is there to talk about the gray smoke that he sees rising from the center of, not Stephen Avery's burn pit, but from the center of the salvage yard pit, that 3 on October 31st, 2005, or shortly thereafter. So, this is, and if the writing was inartful, I take the blame for that. It's my writing. But on the alternative hypothesis that Denny applies, I'm doing my level best here to assemble for what the state did and didn't do, evidence suggesting the least legitimate tendency to believe that these people had no lesser motive than Stephen Avery, no lesser opportunity, and no lesser connection to the place of the offense. I mean, let's take the Dassey boys just to finish. There isn't any physical evidence of direct connection between Brendan Dassey and the death of Teresa Halbach. But this 17-year-old boy is facing the rest of his life in prison on the state's accusation without any physical evidence of a direct connection. Brendan Dassey, for all that appears here, has the same encounter with Teresa Halbach or walks past her as he's getting off the bus that his brother Blaine does. There really isn't any difference here in the apparent motive, opportunity, or direct connection. And when we have Teresa Halbach's bones being found, not just in Stephen Avery's burn pit, which has gotten all the public attention, but something being found in the burned barrel immediately behind the John Doe house, where the 4 Dassey boys live, is that something a jury ought to be allowed to consider in deciding whether the state has proven Stephen Avery's guilt beyond a reasonable doubt? You bet it is. The court, let me ask this. Let's say that if, to the extent that Denny is not on all fours because Denny sought to offer evidence of motive, and you're saying the defense does not, then what does the defense contend are the rules for determining whether third-party liability can be presented to the jury? I'm sorry to be quarrelsome, but I don't know that we're talking about third-party liability. We're talking about evidence of activities and presence of others that has some tendency to make it less likely that Stephen Avery was the person who murdered Teresa Halbach. The court, well, Attorney Strain, this is simply irrelevant evidence. The court, the thing is, if you look at Denny wasn't just saying that one specific other person did it. He is the other person's. He wanted to suggest multiple possibilities. It seems to me that while the defense in this case is not basing its claim on the allegation that others had motive, that in other respects you're trying to do essentially what Denny did. You're saying, look, there were these other people, and I can name them, who were in the position to commit this crime, who could have committed this crime, who were at the scene, had opportunity. Isn't that what you were doing? What the rules are? What are the rules from the defense perspective? What are the rules the court is to apply in determining whether or not the defense will be allowed to elicit testimony that these other person or persons could have committed the crime? Attorney Strang, relevance 901, 904.01 and 904.02, and the ordinary balancing under 904.03. Indeed, I mean, let's not kid ourselves. The state will name the people who were there. The state will elicit testimony under direct examination from at least some of them that they were there at the right time. The state will elicit evidence about the activities of some. The state will elicit, I'm sure, testimony from law enforcement officers about the persons with whom they spoke. So when we explore bias by showing that law enforcement officers immediately narrowed their focus for practical purposes to Stephen Avery, we necessarily have to do that by showing that the broader focus would have included it's just practical stuff. Again, the rabbit hunt is one example, but an example only. That this is a dynamic scene. There are a number of people there, and an unbiased investigation would have pursued many of the facts that we have laid out in the alternative proffer. And admissibility here is the same standard it is for the state's evidence, circumstantial though it is, that Stephen Avery did it, which is, does it have some tendency to make it more likely that he committed the crime? This has some tendency to make it less likely. The court, all right, let me ask Mr. Fallon, with respect to Denny, at least one, setting aside for a moment its significance, whether at least one difference between Denny and the defense is attempting to do, and what is the defense saying? We're not offering a motive for these alternative possible suspects. What's the state's position on this issue? Attorney Fallon, as I indicated earlier, the state's position on that is that Denny is more than just offering evidence about motive. The case stands for the proposition that if you're going to point the finger at a third party, you have to establish the legitimate tendency. You have to establish, which is primarily in the construct of, is there a direct connection? I think that's the operative fact here.